So, hello everybody. We shall start with the next part of the Supreme Court. Last class we have discussed the original jurisdiction of the Supreme Court. In this class, we shall discuss appellate jurisdiction. So, mind you, appellate jurisdiction, appellate jurisdiction. Let me tell you one thing here, that the Supreme Court is the highest court of appeal, is the highest court of appeal, and the here the appellate jurisdiction of Indian Supreme Court is quite broader than the Supreme Court of America, Supreme Court of the United States of America. The Supreme Court can hear cases. The Supreme Court, the SC, hears appeals. Hears appeals against the judgment of the lower courts. It enjoys in the lower courts or tribunals relieve any authority. Constitutional, civil, and criminal matters. Whereas the American Supreme Court, the Supreme Court of the US, hears appeals only in constitutional matters, not in other matters. So that you can say that Article 132 appeals from the High Court in certain cases, that is Article 132, and appeal 133 is regarding the 132 articles, and it is 133 in case of civil matters. 134 is in case of your criminal matters. 134A also certificate for appeal to the Supreme Court by the High Courts, and 135 jurisdiction and power of the federal court under existing law to be exercisable by the Supreme Court. So there are a lot of appeals by the Supreme Court. There are a lot of appeals by the Supreme Court. In case of constitutional matters, the constitutional cases, an appeal can be made to the Supreme Court against the judgment of High Court if the High Court certifies that the case involves a substantial question of law that requires interpretation of the Constitution. So under the certificate of by the certificate of the High Courts, the Supreme Court hears appeals against the judgment of the High Court if the former certifies that the matter or the case involves substantial question of law which requires interpretation. So in a nutshell, we can also say that when the High Court certifies that the case involves substantial question law and it requires interpretation of the Constitution, then it goes to the Supreme Court and Supreme Court decides the matter. Number 2, civil matters. So that is also from the appeal against civil matter appeals against the judgment against judgments of high courts against that substantial question, substantial law that requires interpretation of the Constitution or needs to be decided by the courts, needs to be decided by the Supreme Court. Okay, so that is the civil cases. Okay, okay, then criminal matters. The Supreme Court appeals hears appeals against the judgment of high courts, if the high court has reversed reversed an order of acquittal acquittal of an accused upon accused and sentenced him to death. So, if the High Court has reversed an order of acquittal issued by a subordinate court and has subjected the accused to death sentence, then it will be definitely appealed to the Supreme Court, and after the Supreme Court made it or favored the High Court judgment, then the accused may be punished with death sentence. And has taken any case from subordinate court as a matter of right, subordinate court, and convicted so sentence him to death, and if the High Court certifies that it is certified that number C, if the if the High Court certifies that the case is fit one for appeal to the Supreme Court. So the USS has a broad-based, that is broad-based criminal jurisdictions, and in 1970s the Parliament enlarged the criminal jurisdiction of the Supreme Court. Okay, so in that case, the appeal jurisdiction of the Supreme Court is broader in criminal matters. It has been enlarged by Parliament in 1970, and it has given more powers. Another is appeal by special leave, that is special leave jurisdiction. We shall discuss it in a separate way. The Supreme Court is authorized to grant in its appeal special leave to appeal from any judgment in any matter passed by any court or tribunal in the country, except military tribunal and court martial. Okay, so special leave power Borari, special leave petition Borari, through this power of special leave petition, the Supreme Court can withdraw any matter, any case, decided or undecided, from any tribunal, any court, except military tribunal and military courts, for adjudication by its own. But it is a rare power, so appeals by special leave, appealed by special leave, is a rare power which is sparingly used according to Supreme Court. It is not often used. Okay, now the writ jurisdiction. Writ. So fundamental Supreme Court is the protector of the fundamental rights, the sole protector of the fundamental rights, and it also belongs to its original jurisdiction. And for the enforcement of writ, for the enforcement of fundamental rights, the Supreme Court issues certain writs in the nature of habeas corpus, mandamus, prohibition, quorum, certiorari. Okay, so that is why it is called writ jurisdiction. The Supreme Court has original jurisdiction in the sense that an aggrieved citizen can move the Supreme Court, not necessarily by a puppet. However, the writ jurisdiction of the High Court, Supreme Court is not exclusive. So you can write point wise. SC is the guarantor and defender of the fundamental rights of the citizen. For the enforcement of fundamental rights, the C issues writs like habeas corpus. We have discussed it in your fundamental right class. Mandamus, Quaranto, prohibition, certiorari. The writ jurisdiction, the writ issuing writs. In this regard, the C has original jurisdiction as a person can move the Supreme Court directly for enforcement of his or her fundamental rights. But it is not exclusive. It is not exclusive. It is not exclusive it is not exclusive right, or it is not exclusive authority of the Supreme Court. Rather, the High Courts have also the power to issue writs. They have also their writ jurisdictions for the enforcement of fundamental rights. So, fundamental rights citizen violated, one can approach the High Court and Supreme Court directly, no matter. And Therefore, the original jurisdiction of the High Court is shared between the. It is shared. It's not that it's not with regards to federal dispute is different from original jurisdiction in case of fundamental rights. The original jurisdiction which related to federal matters is completely exclusive and sole prerogative of the Supreme Court, but in case of enforcement of fundamental rights, it is not only belongs to the Supreme Court but also to the High Courts. So it is concurrent with the High Courts, the parties involved. And but one thing is clear is that the Supreme Court cannot deny to entertain such matters under Article 32, but High Courts can deny because Article 32 is a fundamental right, whereas Article 226 is not a fundamental right. So that is also the point to be remembered. They are also different in this regard, and High Court can issue writs not only for the enforcement of fundamental rights but also for other rights, other provisions. Hence, the writ jurisdiction of High Court is wider than that of the Supreme Court. It is only regions. The jurisdiction is wider than the Supreme Court, but the Parliament can confer the Supreme Court the power to issue writs for other purposes also, but so far it has not been conferred, so far it has not been done. Alright, so comparative analysis of the writ power of Supreme Court and High Court. We have told you that writ power is original jurisdiction of the Supreme Court as well as it is the original jurisdiction of the High Court. Both of them have original jurisdiction over the enforcement of fundamental rights. A person can directly move the Supreme Court and the High Courts directly. So it is not exclusive of the Supreme Court. It is belongs to High Courts. Another thing reads High Court can issue writs not only for the fundamental rights but also for the enforcement of other rights. So, and Article 32 is a fundamental right, whereas 226 is not a fundamental right. It means that Supreme Court cannot deny to entertain any matter related to enforcement of fundamental rights, but High Court can do that. But as the Supreme Court has only the authority to issue writs only for the enforcement of fundamental rights, but High Court has the authority to issue writs not only for enforcement of fundamental rights but also for the enforcement of other rights and statutes. Hence, it is rightly said that writ power of the High Court is wider than that of the Supreme Court. Now we shall come to advisory jurisdiction. Advisory jurisdiction of the Constitution, that is 143. It is borrowed from the Canadian Constitution. Okay, it is borrowed from the Canadian Constitution. It is an exclusive authority of the Supreme Court. Exclusive authority means no other court, including the High Court, do not have the advisory jurisdictions. So it is exclusive of the Supreme Court. The President under Article 143, the President may seek advice on any matter related to reconciliation treaties, agreements, standards, etc. In this case, the Supreme Court is bound number two, any matters in this case the SC is not bound. Related to the constitution or the laws and statutes. In this case, the SC is not bound to tender its advice. And in both cases, the advice tendered by the Supreme Court, in both cases, the advice tendered by the Supreme Court the advice tendered by the Supreme Court is not binding upon the President. So this is called your advisory or consultative jurisdictions. It is consulted, and the opinion here tendered by that is not binding. It is not a judgment. It is not verdict. Rather, it is a simple pieces of advice. So it may or may not be accepted by the government. The President is not bound. However, advice tendered by the Supreme Court or you can write clearly, that is called your advisory jurisdiction. There have been many cases where the Supreme Court has been consulted by the government. Some examples are given in many books also, like Kerala Education Bill 1956, and another was Beruvari case in 1960, and Presidential Election case in 1974. So there are a lot of acts like 2G spectrum scam and Punjab Termination of Agreements Act, or there are Ram Janmabhoomi case in 1993, Kaveri water disputes in 1992. So many special court bill in 1978, presidential election in 1974, Berubari case in 1960. All these were referred to the Supreme Court for its advice, but in no way advice is binding upon the president. Okay, then advisory jurisdiction. Advisory. As I have told you yesterday, I told you last class that the court, Supreme Court Supreme Court has the power to revise its own judgments, and no other court can do that. So it is rather a court of revision. It can revise its own judgment. It can revise its own judgment and make it change. So Article 137 contents of the powers of judicial review. The court can the court can the court can revise its own judgment. The court can revise its own judgment, in the case of Goloknath case. The verdict in the Goloknath case was abruptly changed, was substantially changed by the court itself in Kesavananda Bharati case. So there are a lot of changes, a lot of cases where the Supreme Court has revised its own judgments. But remember, the Supreme Court is the only authority to decide its own case, own judgment, or own change in nature. No other court can change the decision or the verdict of the Supreme Court. That is also a point to note it. Okay, so revisory jurisdiction means the SC has the authority to revise its own judgments under Article 137. So I told you in Goloknath case 1967, the Supreme Court held one opinion that fundamental rights are transcendental, but in later cases, the Supreme Court held that fundamental rights can be amended, though without destroying the basic structure of the Constitution, in the famous case Ananda Bharati case 1973. So revisory jurisdiction is somewhat a very unique jurisdiction of the Supreme Court. Then your court of record. Supreme Court as a court of record. Supreme Court as a court of record 129. Here the word cooperative court of record means the court has the tendency of the court's judgments and judgment and verdicts are recorded for perennial purpose, for eternal purposes, for future reference. So all the judgments of the Supreme Court are recorded and cited as a reference by courts or lawyers in different times. So that is what the court of record means. It means that The judgments or verdicts of the SC are preserved for perennial that is what meaning of 129. The courts are preserved for perennial purpose and future reference. The court has the authority to punish on contempt. And the court of record means punish for its own contempt. That means the court can has its contempt. The term contempt is not mentioned well elaborated in the constitution. It is left to the parliament. So accordingly, Parliament appointed a committee, a Centennial Committee in 1960s probably, and the committee recommended for two types of contempts like civil contempt and criminal contempt. Accordingly, Contempt of Court Act was enacted. Accordingly, Contempt of Court Act was enacted. Was enacted in 1971. 1971. Okay, which provides stringent measures against who are subject to contempt. So contempt of courts are of two types. One is you can say one is your court. What is the means civil contempt, and another is criminal contempt. Civil contempt means willful disobedience of the court's order or judgment or summons, and wrongful interpretations. And criminal also means be a hurdle or an obstacle on the way of justice delivery, or to hide the witness, or to scandalize the courts, or publish its judgment in a wrong manner. So all these constitute the what? All these constitute the contempt of court, civil contempt and criminal contempt. So that is the power. So there are two meanings of court of record. One is that the judgments are preserved for the perennial purpose. Another is the court can punish for its own contempt. So that is one we can say the contempt of court. Contempt of court. Also, it is called court of record. Okay. Next is we shall discuss powers judicial review. So, India has adopted the novel mechanism of judicial review by which the judiciary can overview or can review the act of parliament, the executive orders, and any law, legal action, or bylaws, or any other things which violates the constitution or which goes against the spirit of the constitution, and declare them null and void. So, judicial review is a power. Judicial review The Supreme Court examines if the examines if the question act order if the act and order while is in conformity it violates the if it is made by competent authority. So these three things are examined by the court while deciding the cases of judicial review. And in these three cases, if the act does not satisfy, or if the act satisfies one of them, or the act is suffers from this lacuna, then the act will declare null and void. So any act contradictory to the constitution, any act contrary to the constitution is declared null and void. Okay, so this is called judicial review, and it is inspired by American Supreme Court or American court tradition. It was originated in American Supreme Court or American political tradition, and it gives or arms the judiciary with the power to review the act, any act or any law in India. So that is not nothing is beyond the purview of the Supreme Court. And judicial review has been given a trust, a very unique power in the hand of, so not only High Court, not only Supreme Court, but also High Court has made this fact. Okay, so that is called your judicial review. So I told you that is based upon the procedure established by law. It cannot go beyond that law. And another thing, judicial review has been considered a basic structure in the Indira Gandhi versus Rajnaran case 1979. In Indira Gandhi versus okay, so Indira Gandhi versus Rajnaran case 1979, 75. Indira Gandhi versus Rajnaran. It is the interpretational or observer role of the judiciary. So much cases and public interest with the discontinuation of the principle of locus standi has have allowed judiciary to intervene in public issues, even when there is no complaint from the aggrieved party. So judicial review takes place of three dimension, like review of judicial action, review of judicial legislative action, review of administrative action, and also review of any change in the decision of the judiciary itself. The importance of judiciary is that it is essential for maintaining the supremacy of the constitution. It is essential for checking the possible misuse of power. But it protects the right of the people, maintains the federal balance essential for securing independence of judiciary, prevents tyranny of the executive. Limits problems is limits the functioning of the government, violates the limits of power to set, and separation of functions rather than powers to pollute. So, so the concept of separation of power is not adhered to strictly. However, a system of checks and balance have been put in place. The judiciary has the power to strike down. Okay, that is called your judicial review. Next, we shall come to other powers. Other powers of Supreme Court. Next, the Supreme Court decides The disputes related to the C decides the dispute related to the election. Election of the President of People, number 2. It decides the matters of behavior. Against the chairperson, and members decides the matter of misbehavior against okay, so that is the case of your other powers. We discussed it, other powers. Okay, so it inquires into the conduct and behavior of the chairman of deputy members of the EPSC, chairperson and members of parliament, members of EPSC. Central Information Commission, etc. Okay, so its laws. Its laws are binding on all courts in India. It is the power to issue decrees and orders. Powers of judicial superintendence. She has the power of judicial review, judicial superintendence and control over the case. Control over the subordinate courts, you can say. So we can say that with respect to matters in the union as well as emerged by the parliament, further its jurisdictional powers with respect to any other matters can be enlarged by the special agreement of the centre and states. So the Supreme Court jurisdiction and powers with respect to matters in the union list can be enlarged by the parliament. Further, the jurisdiction of Supreme Court powers with respect to other final which will be enlarged by emergency against the center and the states. Okay, so this is all we have covered. And there are Supreme Court advocates, senior advocates. They are advocates who are designated as senior advocate by the Supreme Court of India by the High Court. They can designated by advocate with his consent. The senior advocate gives its opinion a virtue of his ability and standing bar of special knowledge, experience in the law. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without junior advocate record. On the only these advocates are entitled to file matters or documents before the Supreme Court. They can also be they can also be they can also file an appearance, an act of the other advocates are there. Okay, so these are the things, and we have discussed also the important articles. Okay, so we shall proceed with the judicial high courts, but before that, let me just tell you. So that is Supreme Court or Judiciary Supreme Court. So we'll just see that which. Okay, so I think we'll discuss certain questions, possible questions which are required. So we'll see the core questions first. Then we'll proceed to judicial review and other things. Okay. So we can now look at certain questions which are required. We will discuss some questions. Please work out it. So, what will be the answer to the question number one? A will be there. Justice Dhananjay Y. Chandrachud is the 50th Chief Justice. Let me see how many questions are there. So it is both of them are correct. Justice Dhananjay Y. Chandrachud is the 50th Chief Justice, was appointed by the President on 9 November. C. That is A. Consider the following. Consider the Supreme Court came into existence on 28 January 1950. All right. The predecessor of the Supreme Court was Federal Court of India. All right. Both the courts had the same independence and autonomy as the highest court. Not right. Article will be 1C. How many judges are there in the Supreme Court? There are 34 judges, including the Chief Justice. 33 judges and plus one Chief Justice, so 34 judges of the Supreme Court are there. Who appoints the judges of Supreme Court? Very interesting question. The judges are appointed by the President. So, with the recommendation of collegium is there. Even the following is not a criterion of being eligible to be judge of the Supreme Court. Judge of one High Court or more than at least 5 years. An advocate of Supreme Court for at least 10 years. A distinguished jurist in the opinion of the President. Just a minute. So which one the following the criteria for eligible to be a judge of High Court? Judges of one High Court more at least for 5 years, right? Advocate of about 10 years, distinguished jurist. D. D is the answer. No minimum age. Okay, no minimum wage. Which of the following deals with the establishment of National Judicial Appointment Commission? Hmm. Provided under 99th Amendment Act, and it was established under National Judicial Appointment Commission Act 2000, 2000, it is 2014, 2014. But as you know, both the amendment and act were declared unconstitutional by the Supreme Court in the fourth judge case 2015. Who is appointed as the Chief Justice of India? The President appoints the Chief Justice of India on his sole discretion. No. Yes. B. Who appoints the ad hoc judges? Among the following statement is not true about the procedure to remove the judges of Supreme Court of India. It's correct because President issues an order. It is also correct. Mhm. Question number 11. What does the writ of habeas corpus mean? You got the answer? It's A. Mhm. What does quo warranto means? It is issued when an office holder is found misuse his duty. No, because it is mandamus. Authorities. It is mandamus. Who was the Chief Justice of India? First Chief Justice of India. Where is it? B. Who among the following was instrumental in introducing PIL in India? That is Justice P.N. Bhagwati. Also, that was V.K. Krishnaiyer. There, what answer will be A. Look at question 15. The advisory jurisdiction belongs to only Supreme Court of India, right? Supreme Court of India is bound to tender its advice on all matters referred to it by the President. Is bound, not bound. It is also known as epistolary jurisdiction. No. It is known as consultative jurisdiction. Okay? Which of the following article deals with the Supreme Court as a court of record? So that is 129, 142, Okay. Number 8. Who among the following is the longest serving CJI of India? YB Chandrachud. Who administers oath to the judges of Supreme Court of India? Who among the following has not been Chief Justice of India? G.K. Krishna Iyer. D. J. First attempt to impeach was there, was made against, so somewhat wrong interpretation questions, because you can say Justice B and sorry, B Ramaswamy. So that will be the answer. In 1993, he was the first judge against whom impeachment removal resolution was initiated but could not be passed due to the bill was failed. The motion resolution was failed in the Lok Sabha. Under which of the following circumstances the acting Chief Justice of India is appointed? What is your answer? What is your answer in this respect? What is your answer in this respect? All the above. Yes. Next, 24. The Supreme Court can issue writs not only for the purpose of enforcement of fundamental rights but also for any other purpose. Incorrect, incorrect. Any other purpose. High courts can issue writs of injunction where Supreme Court cannot issue writs of injunction. The Supreme Court can issue writs only in case of appeal, whereas High Court can issue writs only when the party directly approaches it. Wrong, wrong, wrong. High Court can issue writs only for the purpose of enforcement fundamental rights but for other purposes. Writ of injunctions. Okay, the answer will be only 4. 25. Okay, so establishment of Supreme Court. Supreme Court as a court of record, appellate jurisdiction in civil matters, appellate jurisdiction in criminal matters. 1, 2, 3, 4 will be the answer, not number, but it is there. 1, 2, 3, 4. Which of the following is regarding correct? It is binding on the Supreme Court to give its opinion any matter report. No. The full bench of Supreme Court hears any reference made it to the under its power of advisory jurisdiction. Yes. The opinion given by the Supreme Court on reference under advisory jurisdiction is not binding on the government. Yes. No more than one reference at a time can be made to the Supreme Court under its power of advisory jurisdiction. I think it is 2 and 3. Okay. So there are 3 questions more. Consider the following sentence. Article 131 says if there is a federal dispute between state and central, then Supreme Court has exclusive power. Yes. If it is a there is a federal dispute between, then High Court has the exclusive power. No. The judges of High Court can remain in office till the completion of 62 years. Yes. So 1 and 3 only. Any resolution passed by the Parliament for removing the judges of the court has been investigated by a committee comprising of yes, 2 judges, including CJC. Which one of the following is a not applicable to public interest litigation? We have not discussed, but still, constitutional obligation of the judiciary towards marginalized sections that is applicable. Locus standi is not applicable, means it can be made so motor. Locus standi means the right capacity to bring an action or to appear in court. So it avoid means the aggrieved party may not lose the case, but it will be heard by the court. It is because it is of more public importance. Hence, this is known as public interest litigation. So there is no need for the aggrieved party or the victim to move the case. Not necessary. Okay. So this is all about the questions on Supreme Court. Another question you can see 30. Which of the following is correct? Triggered judge of the Supreme Court. The judge of Supreme Court is appointed by the President of India. He holds office during the pleasure of the President. No. Okay, so that will be 1 and 4, I think, 1 and 4. So get the questions, view, and very important questions are there. So we have discussed the things, and so there is 30 questions you have discussed. There are not more than questions. In the next class, we shall be discussing issues related to judiciary like judicial review, activism, and other parts things. Okay, we shall discuss the judicial review, judicial. Then we shall discuss first the high courts and others. Then we shall come to that. High courts and subordinate courts. Next class, high courts and subordinate. Okay. So till then, let me goodbye. Goodbye. Stay tuned to our courses. Okay, we'll update you and carry you with your updated courses. Have your constructive comments and watch our YouTube classes frequently and regularly also. Okay, thank you very much.